Good evening, good evening, good evening. Hello, everyone. Thank you for being here this evening. We're so grateful that you are joining us tonight for our 4th annual Holding Court Supreme Court Term Preview. My name is Rachel Rossi, and I am the new president of the Alliance for Justice and Alliance for Justice Action campaign. We are committed to building power, transforming courts, and securing justice for all. This event is part of our ongoing series, Holding Court Justice Conversations with AFJ, featuring leading activists, legal scholars, elected officials, and attorneys who join us to discuss current political and social justice issues. Tonight, we are going to hear from speakers and panelists to preview the upcoming Supreme Court term, which kicks off on Monday, October 6th. The Supreme Court docket is filled with cases that could have significant implications on voting rights, trans rights, campaign finance, and much more. I want to thank all of you for coming out to join us tonight, especially at a time when not everybody feels safe going outside here in the district. But what continues to inspire me in this moment is the resilience and the strength demonstrated by the people here in DC and the people across this country. And remembering those who came before us, whose shoulders we stand on as we continue the fight for freedom and equality. In fact, we are surrounded by some of that history right here in this Langford Auditorium. John Anderson Langford, whom the auditorium is named after, was the city's first African-American registered architect, and he designed this building. This was actually the very first building in the country to be designed, financed, built, and owned by the African-American community after Reconstruction. One of Duke Ellington's first performances with his group, the Duke's Serenaders, took place right here in this very auditorium. So I know that today it can be difficult to feel that spirit of resilience and strength. It can feel like even standing together, we are powerless, or that there's nothing that we can do to push back, especially when we're looking at the Supreme Court. When we look at what we've seen the court already do, the demonstrated willingness and intention to roll back rights and empower an anti-democratic power in the executive, especially when just yesterday the Supreme Court ruled that at least temporarily federal agents have the green light to racially profile. And especially as we tonight prepare to dive into the upcoming Supreme Court docket, where much of our conversation today will preview even more significant potential threats to democracy, voting rights, and more on the horizon. All right, I want to pivot for a moment to talk about the Louisiana versus Calais case, and this is for any of our panelists. This is a case that addresses redistricting. We know there's a lot going on right now when it comes to redistricting. Does anyone have thoughts on the case, on the implications, on broader implications than beyond Louisiana?
Yeah, so I'll start us off. I mean, the weird thing about this case is the court actually heard it for argument last term, and they're resetting it for argument again, which is pretty rare, and that suggests some divisions on the court. It also historically in the Roberts Court has portended the court going big. That's what happened in Citizens United, for example. And so, the court may be testing their appetite to further weaken the Voting Rights Act. This is a case about a district in Louisiana. Louisiana's population is about 1/3 Black, but the maps only allow one majority Black district out of 6. And the lower courts found that diluted Black voting strength in violation of Section 2 of the Voting Rights Act. That's the part of the Voting Rights Act that the court hasn't completely gotten rid of, at least not yet. And so the court has already said you can't have partisan gerrymanders. They're not going to do anything about that. And the question now is whether the court will severely limit the ability to police even racial gerrymanders, which are kind of at the heart of the Voting Rights Act.
I think for me, from a advocacy point of view, my grandmother was born in 1953. And she can remember when her mom was first able to get a bank account by herself. She can remember when she was able to vote. So we are seeing the rise in fascism in so many different ways. And I'm hoping that more people do not become discouraged when it comes down to voting, right? I'm hoping that people see this as an opportunity to not only cast their ballots in national elections, but even the local ones, right? You know, I was born and raised in Beaumont, Texas, right? And there we have to vote for the sheriff, the small little justice of the peace, people that have autonomy and power in ways that now that I'm a full adult, I'm like, I don't even think my grandmother understood the significance of the vote at that time, right? This was the person who had to hold what it meant for young adults to show up and be themselves, right? And so, what is happening in Louisiana, what is happening in Texas, what is happening in California, it is levels of intention. And let's be honest, gerrymandering is used on both sides, right? So, but when it becomes more heinous, that's the problem. When you're gerrymandering to ensure that you can remain a dictator, that's when it becomes a problem. When we have a constitution that clearly states what you can and cannot do. And I think for me, midterms are really going to show us what to look forward to in 2028.
Great. And so just sort of stepping back and thinking about, like you said, Alan, how these greater implications, you know, not even the case itself, but just the public hearing about these cases, hearing about the redistricting can be chilling the right to vote, and how we're seeing such a coordinated strategy to empower the executive branch. I want to talk a little bit about the attacks on independent agencies. So we've seen many different attacks on independent agencies from this administration. And we're going to see two cases on the on the Supreme Court's emergency docket orders, and the Wilcox and Harris cases allowed for the removal of officials from the National Labor Relations Board and the Merit System Protections Board, respectively, despite statutory for-cause removal protections. So Deepak, can you tell us, what does the use of the emergency docket in these high-profile cases tell us about the court's approach to administrative law and precedent, and sort of explain all of this for us and lay it out? What are we going to see here?
So these are, I think, like profoundly important cases, and there's a whole bunch of them now that are accumulating in the lower courts and kind of at the Supreme Court's doorstep. And you know, on one level, factually, they're about the fact that President Trump went on this unprecedented firing spree, right? He went and he fired the heads of these independent agencies, including Gwynne Wilcox, who, full disclosure, she's my client, and she's the first Black woman to head the National Labor Relations Board. And he also fired, attempted to fire Lisa Cook from the Federal Reserve, also a Black woman. I don't think that's a coincidence. He's kind of tried to make these people, targets as part of this firing spree. And that's disturbing, but what's behind that is even more fundamental questions about the power of the presidency, the power of Congress, and the way that our government is structured. Because these protections from firing by the president, that is the way that Congress makes agencies independent. Agencies like the National Labor Relations Board, like the Federal Trade Commission, like the Federal Reserve. And Congress did that for a reason. It did that because these are really critical functions that Congress, for over a century in our history, has decided should be led by experts. We don't want people, monkeying with interest rates because of how that's going to affect an election. And so there's a long history, a settled understanding between the branches of government that this is how our system is set up. And President Trump has done what Justice Kagan said recently in the order that Rachel's talking about. He's taken the law into his own hands. He didn't wait to go to the Supreme Court and litigate it and argue about it and then get a decision about what he can do. He just went around and fired all of these people in a way that no president had ever done before. And the district court judges did their jobs. They all enjoined each one of these firings. And that's, I think, part of a similar pattern that we're seeing across these executive actions that have been challenged. The district judges are doing the hard work, at great cost to themselves. They're being threatened, and they're enjoining these actions. But then when they get to the Supreme Court, on the shadow docket, even without argument, the Supreme Court is reversing those decisions. And we saw that in the NLRB and Merit Systems Protection Board case. We saw it again with the case about the Consumer Product Safety Commission. And what's especially disturbing about that is there's a precedent on the books that answers this exact question. It's called Humphrey's Executor. So if you've heard about that, or you heard about the unitary executive theory, that's what this is all about. It's a battle between people in the administration who believe in this thing called the unitary executive theory, the idea that the president can do whatever he wants, and people who believe that that Humphrey's Executor case, which says Congress can set these limits, that's the law. And so the court didn't overrule Humphrey's Executor. It actually didn't even cite or mention the case. It just allowed President Trump to do this without any explanation. And I think, to your point, Rachel, about the shadow docket, that's part of a pattern that we're seeing where the court is, disregarding precedent or not really addressing the precedent, and yet reversing these decisions by lower courts that are just kind of following the existing law. And, there's a lot that's disturbing about the way that the court is doing its job, but that way of doing its job really runs up against basic notions of how we think about the rule of law and the transparency of the process. If you are going to make this decision, at least tell us what the decision is that you're making and why you're making it.
Can you say a little bit more about the shadow docket for those that may not know what it is? What is the shadow docket and why is it so concerning?
So the shadow docket, by the way, is kind of a controversial term. Some people like to call it the emergency docket, but before a few years ago, it was not a big feature of what the Supreme Court did. I mean, there were death penalty cases that went there, but as a general matter, the court was, not doing most of its work on these emergency applications. It was doing its work through the normal course where the cases were briefed and then argued. And now what we have is that this shadow docket, these emergency applications, are kind of overshadowing the regular stuff that the court is supposed to be doing. So a lot of these things you're reading about in the newspaper that the Supreme Court is doing, they're doing them on very, abbreviated briefing with no argument, like that order yesterday. The order yesterday that said that it's okay for the administration to be doing these roving immigration patrols and racially profiling, reversing, again, an order by a district judge that was just applying the law. And and we've had just a series of these decisions since the Trump administration started, allowing the administration to do things that are unprecedented without a full process. And so I think, everyone should be aware that that's happening. And when we're thinking about ways to maybe, reform or address the processes of the court, that's maybe one place to start.
Now, I don't want to leave us on a down, sour note. Let's talk about what we can do. Is there anything we can do? The first question I have is, and I'm sure we're guilty of it up here a little bit, but whenever we talk about SCOTUS, we can get bogged down in legalese. We can get into our own world of scholarly conversations, right? So how do we get people who are not in this world to care? How do we help regular everyday people understand what the stakes are? How do we make sure we're doing this regularly in our work? And why is it important?
Can I take a quick poll? How many of you have heard of principled struggle? Can you raise your hand? Oh, we have what, 2? Okay. Principled struggle means I may not agree with you on the tactic, I may not agree with you on why, but I'm not your enemy, right? And right now, we need to be in principled struggle and principled disagreement with as many people as possible. That's how we're going to get to liberation. We have to put our differences aside. We have to look at ways to engage our neighbors and figure out, what does dignity look like, right? Up until I started working for the task force, I was in the immigrant rights movement, and there were a lot of things that I didn't know at all as a gay man in my 30s. And then I started working for the task force, and I was like, what the is that, right? I started learning so many new things. And so I want to challenge people to learn something new. I want to challenge you to reach out to your neighbor when something is confusing, to follow the task force and ask questions. The more questions we ask, the more we can overturn the mis and disinformation that is infiltrating our communities, because that is the reason why so much of the opposition is winning. So many people are confused about what they hear and see. They don't know who the trusted messengers are. So I hope when you look at my beautiful Black face, you go follow the task force and you say, I'm going to listen to what they're saying, and I'm going to agree to be in principled struggle with my neighbor.
Well, this may be the bias of someone who has worked now for decades in voting, elections, and campaign finance, but I really think that we cannot be defeatist, and we absolutely have to go out and vote. We need to get registered, we need to get other people registered, we need to not give up. I really dislike all the talk about, if there is an election, or will there be an election in 2028. I don't think we can or should remotely accept that type of vision of the future or accept that type of defeatism. I think this is the way that we change the court. This is the way that we change our policies. I realize it probably feels very, and it does to me too, very inadequate in these days where we have months and years before even that change can happen. But I don't think, we should assume futility where there really is none, particularly because that will be the defeat that, the forces that are trying to consolidate power are hoping for.
I think this is a really, really difficult problem because we're living through this very authoritarian moment where the courts are actually the only branch of government right now that we can turn to even try to restrain what's happening. And at the same time, increasingly, and especially through these shadow docket decisions, the court seems like it's comfortable being complicit in what's occurring. And I think, there may be a tendency for some of you to say, well, the court is just such an illegitimate institution that we should just kind of, attack courts. And that's the wrong move, right? That actually, I think, buys into the project, the authoritarian project. We do need a functioning legal system. We do still have a functioning legal system. Like we're criticizing the court, and it's actually a relatively small slice of the court's docket that are the highly politicized cases, but there's still a functioning legal system. And, the executive branch is still largely following court orders. And that is not something that we can take for granted. And there have been moments where I have, over the last several months been really worried that we had passed that point. I don't think we have. And I think, the fact that we're asking about it so much means we are in a kind of constitutional crisis. But there's a different kind of constitutional crisis where, the people in power don't even have to obey court orders. So I think what we need to do is educate people about the importance of the courts, the reality of what the court is doing. We need people that are educated voters who care about this. But I just resist, maybe this is, my bias as a lawyer, I want to believe that there's such a thing as law, but I don't think you can just kind of throw the baby out with the bathwater.
I love that. All right, well, we're going to turn to talk to answer a couple of audience questions, and then I'll give you all just a quick moment at the end for any final thoughts or calls to action or other statements for our audience. So one of our audience asked, how can we encourage lower court judges to ensure they are dealing with the legal issue in front of them and not trying to opine on reasoning from a 2-sentence procedural shadow docket order that is not precedent setting for fear of being reversed on the shadow docket later? It's a tough one.
I mean, so what I think the questioner is getting at, I don't know if you all saw this news about this judge in Boston, Judge Young, who's a really good judge, who apologized to Justice Kavanaugh and Justice Gorsuch. And I don't know how sincere he was being about the apology, but what he was saying is, like, I would never defy a Supreme Court order. My job is to follow them. But I didn't know at the time that I issued this decision that you were on the shadow docket going to change the precedent. And at least historically, those shadow docket orders didn't change precedent. So, and we saw this also in a judge in the Harvard case said something similar. Actually, kind of criticized the court for this. So I think this is it's a real problem for the lower court judges. And it's why they shouldn't. The court shouldn't be doing what it's doing on the shadow docket. We don't actually know what the law is on some of these topics. We don't know what the governing precedent is, which is really, really destabilizing.
Any other thoughts? Okay, second question from our audience. Last term, the Supreme Court handed down a landmark decision in Trump versus United States. Does the presidential immunity extend to defying court orders? Does it provide authority for presidential executive orders over and above constitutional separation of powers?
No.
A brief answer from a lawyer, you guys. Take that and run with it.
Well said, well said. And for folks that recall the Trump versus United States case and the sort of far-reaching implications for it, understand why that important question is asked. This is another question from our audience. Is the current makeup of the Supreme Court the long ago thought blueprint of the Federalist Society? And if so, do we have a similar thought out plan to transform the Supreme Court to a court that respects the rule of law, returns us to a court that bends toward justice?
What a great opportunity for a plug for Alliance for Justice. For those who don't know, Alliance for Justice has been the kind of central organization doing judicial selection rights. And one of the things Alliance for Justice does is, even when we're in this moment of when we're in the wilderness and in the darkness, it's planning for what happens when there's a different occupant in the White House. And part of the project is building a pipeline of people who are, there's going to be a moment where we're picking up the rubble of this time that we're in, and Alliance for Justice is planning for that kind of rebuilding. So I hope you can support the organization in its work.
I co-sign all of that. All right, last audience question. What do you think about Amy Coney Barrett's difference in her shadow docket emergency decisions versus her regular longer-term case decisions? That's a real deep question. We may have to get back to you on that one.
I don't think she's any different from the rest. I think there is just
That would be my intuition too, that for all the same reasons that my co-panelists have outlined, it's problematic to shadow docket because there's so little reasoning at all.
And on that note, I would love for each of you to close out with just a final thought, question I may not have asked you, a call to action for our audience, or thoughts that you want to leave folks with.
Go for it.
Is it working now? Oh, okay. You know, I'm a lawyer. I argue cases. I argue cases in the Supreme Court. We had 4 cases there. Last term, we actually won 3 of them. And I think when we're focusing on these really big, you know, politically controversial cases, we forget that there are a lot of cases that come through the courts that affect the lives of consumers and workers in their everyday lives, the relationships that they have with corporations. And, you know, we're continuing to litigate those cases, including in the Supreme Court, and we can still win those cases in ways that affect people. And sometimes we do that, you know, by making textualist or originalist arguments. Like, you know, if it were up to me, we wouldn't decide really big, important, complex questions in our society by asking what a dictionary said about it in 1789. But like, if I have a client and it's going to help that person, you know, sue their employer or you know, get overtime or, you know, fight a bank that's cheated them, like I will make those arguments. And so I do want to just, you know, emphasize that there's still a role for law and for lawyers and for, you know, anyone who's thinking about law school or if you're law students. Like the project is not, you know, dead. There's still lots of important work to do, and it affects real people's lives.
Yeah, I think that's a really important point because although my organization, Campaign Legal Center, focuses probably more than anything else on litigation, we are also advocates. We're also creating legislative policy solutions. And one of the big questions that keeps coming up is how much do we focus on the moment and the unprecedented dangers of this administration? And how much do we keep the work of pushing reforms that we think we've needed for decades in the system? You know, there's plenty of things that are not even before the Supreme Court. We could do public financing, we could do ranked choice voting, we could do, you know, nonpartisan primaries. There's so many different ways to create a fairer election system and maybe fairer governance, better disclosure, more transparency, creating transparency in AI usage in elections, the whole world of digital political advertising. There's so many spaces where I think we can improve the public discourse, politics, election engagement, that we shouldn't give up on this longer term project of free and fair elections and a, you know, more inclusive and accessible government, even as we have to rise to meet this moment. So I do try to keep both tracks in mind, that we both have to meet the moment, and we have to make sure that we don't, you know, allow to drop on the wayside these much longer term hopes and projects for a, you know, better democracy.
Hashtag not a lawyer, which is why I looked at them anytime it was a legal question. All of you can be activists and advocates. All of you can establish more direct relationships with your congressperson, even if they do not align with your political views. They take your tax dollars, you send them an email. You don't like something, you comment on Facebook. If you see something, you say something. I think in this moment, we are trying to build more tolerance of what is around us. But oftentimes people think in engaging with a Congress member is scary, right? It's like, I don't know what to say. Tell them vote for the right thing. Tell them value my child. Tell them think about the dignity in the way you show up. And another thing that you can push them on is to go across the aisle and push their colleagues to do the same. Right? We are seeing a rise in Christian nationalism that is ingrained in Congress in so many different ways. Oh, you're a Christian? Are you loving thy neighbor? Are you treating thy neighbor with the same respect and dignity that Christ would have? And leaning into some of those things where we all learned something new today, right, y'all? Principled struggle. Where we're going to lean into that disagreement. We're going to lean into probably not liking what this Congress member has to say, but I'm going to listen, and then I'm going to tell you, you take my tax dollars, this is what I need you to focus on, right? And I I've been lobbying for quite some time, right? I've been having intentional conversations with members for a while. And one small conversation, one small personal story can change one vote. And there are going to be plenty of things coming across the aisle that we need to have members that are willing to not just hold the status quo, but show up for.
Thank you for that. Please join me in thanking our fantastic panel, Alan, Tara, Deepak. Thank you for your expertise, and thank you for being with us. Our last speaker this evening, we are very delighted to have with us today Congresswoman Mary Gay Scanlon of Pennsylvania's 5th Congressional District. Many of you may know Congresswoman Scanlon serves on the House Committee on Rules, House Judiciary Committee, and serves as ranking member of the House Judiciary Committee's Subcommittee on the Constitution and Limited Government. She chairs the House Caucus on Access to Legal Aid, and I was inspired by her leadership and proud to collaborate with her in my last role when I served as Director of the Office for Access to Justice. She also chairs the caucuses on youth mentoring and foster youth. And prior to her time in the House of Representatives, Congresswoman Scanlon served as a national pro bono counsel, where annually she oversaw 600 lawyers providing more than 50,000 hours of pro bono legal services around voting rights, child advocacy, immigration, public benefits, and criminal justice reform. We are so honored to have you with us here tonight. Please give a warm welcome to Congresswoman Scanlon.
All right. Thank you for having me here tonight. I listened to that introduction, and every time I hear the current name of my subcommittee, it's like fingers on a chalkboard. It is properly named the Subcommittee on the Constitution, Civil Rights, and Liberties, and it will be again. So thank you, Rachel, for the introduction. As you said, we've had the opportunity to work together in the past with the Office of Access to Justice, which we were so proud to get reinstated under the Biden administration, and to work together to make the case for robust legal aid funding and access to justice programs that help people across the country. So unfortunately, in this House administration and with this House majority and this administration, the focus on access to justice and legal aid has fallen by the wayside. Although we continue to make that case, and in fact, I think next week or the following week, we have the Legal Services Corporation coming to talk to our colleagues about how legal aid can help when there's a natural disaster, because we know how important it is that people know their rights in that situation. But let's talk about the fight that we're in right now, the fight that is consuming our government. Given the urgency of the current moment, it's clear that this Supreme Court term will have a profound impact on our constitutional order, whether because the court leads or avoids leading with respect to the grave constitutional issues that we're facing. And I always feel like in this moment, I feel like I should issue a trigger warning. There's a lot of bad news right now, but I think together we can brainstorm solutions. So you've been talking about what's at stake on the court's upcoming docket, whether it's young people's civil rights, the future of the Voting Rights Act, fair representation, the further exposure of our political system to the corrosive effect of dark money in campaign finance, and that's got to be a priority for reform, and the ability of persecuted people to obtain asylum status here in our country. These are the kinds of rights, liberties, and protections that the court should protect, and that Congress should legislate to safeguard and expand. And as a member of the House Judiciary Committee, those are the policy issues I came to DC to work on, but that's obviously not the focus of this Congress. Under Jim Jordan's leadership, the entire Judiciary Committee is just a place for the president's allies to cheer on his administration's lawlessness and to promote divisive culture wars, and to sit back and allow the power of Congress, the power of the people, to be disregarded. I know I don't have to tell all of you that we're at a precarious point in American history. We have a country that was built upon the rule of law, not the rule of a king, and it's built upon the idea that no one is above the law. But right now, this administration's actions repeatedly fly in the face of that constitutional order. Since day one of this administration, Trump and his Project 2025 allies have sought to undermine the separation of power that are enshrined in our Constitution. They've been pushing this agenda you were just speaking about, the formerly fringe theory of unitary executive, which baselessly asserts that the president has unlimited power to control the executive branch for his own political ends, and that Congress can't limit that power. It's an argument to which my dear friend Jamie Raskin would say, our Constitution did not create co-equal branches. Congress is first in Article 1. Congress is the branch of government most accountable to the people. That's why we make the laws and direct spending. The president's job is simply to execute the laws that Congress passes, not, as this White House seems to think, to execute as in kill the laws themselves. So despite the clear constitutional intent and more than 2 centuries of precedent, we've seen this president remove the leaders of independent regulatory agencies, shutter congressionally authorized agencies altogether, defund important programs. Earlier this year, he approved the bombing of a foreign nation, blatantly ignoring that the decision to wage war rests with Congress. And last week, he ordered the execution of 11 alleged Venezuelan drug dealers on the high seas, although there's no legal basis for such an extrajudicial killing. He's repeatedly usurped Congress's power of the purse, illegally impounding funding, and we know what's coming next. Cleta Mitchell and Project 2025 have laid it right out for us. This administration and its allies want to gerrymander and suppress the vote, militarize our cities in order to destroy the core feature of our democracy, free and fair elections. In response to all of this, every member of Congress should be standing strong for our constitutional system and for the American people who we represent. But instead, our Republican colleagues are held hostage by this administration, refusing to push back, refusing to defend their own power, or even to protect their own constituents. So while it's clear that the demise of the Republican Party as it once existed is undermining Congress's role, that makes it more important than ever that the courts step up to check presidential power, deliver justice, and safeguard our rights and freedoms. It's clear this administration hopes that the accountability system enshrined in our Constitution won't hold. But the courts especially should not be in the business of enabling this president's abuses of office because their power's at stake too. Our constitutional order is premised on the various branches jealously guarding their power. And we're seeing Congress under Republican leadership and even the courts under this Supreme Court giving up that power to all of our detriment. So that's obvious by the way this administration and its allies are already stooping to attack individual judges, undermine court rulings, and discredit the judicial system for functioning as it should. And we hear that from our judicial colleagues as well. One thing is certain, the presumption of regularity, the idea that the president and his administration can be implicitly trusted to abide by the law and to be candid with the courts, is fundamentally damaged right now. And every day this White House is proving it. The court system has to grapple with the reality of an administration that is acting in bad faith. And it must respond to that because our democracy is on the line. So just look at some of the things that are happening. The Attorney General is acting like the president's own lawyer. where we see 50 years ago, just over 50 years ago, President Kennedy asked the nation's leading law firms to step up and form the Lawyers Committee for Civil Rights to protect civil rights across the nation. This president's gone after many of the same firms or their successors for having tried to hold him accountable or taking on cases or causes that he doesn't like, preventing them from protecting people's civil rights or immigration rights, compelling them to divert their resources to causes for his own political ends, and denying access to justice from those who may need it most. This president has declared nearly a dozen national emergencies that don't really exist, as a guise to impose illegal tariffs, deport people without due process, and dispatch the National Guard and military to face off against their fellow citizens in our cities. And while history would lead the courts to defer to the president's judgment, this moment demands a different approach. He's made corrupt quid pro quo deals, raking in emoluments from across the globe, whether it's Qatari airplanes or crypto deals, moved to drop federal corruption charges against New York's current mayor in exchange for political favors, accepted massive, record-breaking inaugural fund donations, and then issued pardons and dropped enforcement actions against the donors. So we've seen states' attorneys general, civil rights groups, and unions, and some of the people in this room challenge the administration's actions. And while I've been sorely disappointed by those law firms, universities, or media outlets that have caved to the president's bullying, forfeiting control over their operations, and acquiescing in extortion of federal funding, or worse, payoffs to his campaign or presidential libraries, I've been cheered by those institutions that have understood the importance of standing up in this moment and have by and large been successful in doing so. Because when litigants have stood up to protect their members or their institutions, they've generally been successful. Lower courts and appellate judges appointed by presidents of both parties have pushed back, forcing the administration to comply with the law, and we need them to continue doing so. As this administration tests legal limits and boundaries, it's clear the law matters now more than ever. But so far, the Supreme Court, the one this president stacked, hasn't met the moment. In the words of Justice Ketanji Brown Jackson, the Roberts Court is playing Calvin ball, a game where there are no fixed rules, but in this version, the administration always wins. Using its shadow docket at a rate never seen before, the court is overturning lower court decisions with little to no explanation, a pattern that federal judges are now saying makes it harder for them to do their jobs to defend the rule of law as they find themselves on the front line of protecting our constitutional order. And the Supreme Court's efforts to avoid or excuse confrontations with this administration serves only to enable the right's unfounded attempts to delegitimize judges and courts when they rule against this president. These wannabe authoritarians in the White House want people to believe the rule of law is hopeless in the face of their chaos. And we can't buy into it. All of us can't buy into it. This matters, and we as Americans have to keep believing and acting on that foundational pillar of American government. I do want to appeal to everyone in this room to keep fighting, because you all have an important role to play. As was just suggested, you are the trusted messengers. You understand the stakes. You understand the tools. Please continue to use your voices and defend our democracy. Keep using your expertise and your passion for justice in the courts and in educating the public about our constitutional system, how it's under attack, and why that matters. Things can seem kind of dark as we see this constant onslaught of crazy, crazy news, but this is a generational battle, and it is a battle worth winning. I was reminded of this weekend when I attended a service in one of the Black churches in Southwest Philadelphia in my district. The preacher very clearly reminded all of us that our country has seen dark days before, when those in power tried to suppress voting rights and personal freedoms and to rewrite history. And she invoked an image of sowing seeds, which I think are applicable to our quest for liberty and justice. To paraphrase, she said that some seeds fall on infertile ground. They're ignored and blown away before they can bear fruit. Some seeds land on thorny ground and are choked by corruption and the thirst for power. But those seeds that fall on fertile ground prosper and bear fruit. You are the fertile ground. You understand the power and promise of liberty and justice. You have the skill and the will to help bring those seeds to fruition. So I'm going to ask all of you to please join with us to continue to cultivate those blessings of liberty and overcome the challenges of drought and thorny ground as we all strive together for a more just and a more fair America. Thank you.
Thank you, Congresswoman Scanlon. Thank you for your leadership. Thank you for fighting for us, and thank you for being here with us tonight. As we close out our program tonight and we reflect on the fights ahead, the challenges are many, but it's so evident that we have the wisdom, the strategy, and the grit to counter them, especially when we stand in coalition together. We are going to continue to hold this court to account, both for its egregious ignorance of the law and for its ongoing corruption. We're likewise going to continue to hold this administration to account to protect our republic and the democratic ideals that we hold dear. And we're not going to lose sight of the future that we're fighting for, an independent, ethical, and progressive court that represents and defends justice and the rights of the people. We can't always see the arc of the universe as it bends, and it's in those moments that we have to remind ourselves that we have a role to play in ensuring that it does, in fact, continue to bend toward justice. We are at a pivotal moment for the courts in this country. And I just have to say, we are delighted that you're here, that you're with us. We're so grateful that the Alliance for Justice Board is here with us. We're grateful for all of the partners in this room that have worked with us in this fight. And if you believe that the work that we're doing is important and you want to join in and help us to shape a more just and equitable future, I invite you to make a gift to AFJ. Every donation, small or large, it matters. Or just get connected to us, get connected to the work that we're doing, to the resources, to all of our future events, and just stay plugged in. Because the truth is, the courts belong to the people. And if we fight together, we will take them back. Thank you so much for being with us tonight.